Hello, my name is Solomon Ramos. I am part of the criminal justice class and today's topic is over what is my interpretation of the Equal Protection Clause, and are there any courses correctly or incorrectly interpreting its meaning. So, I think my interpretation of what the 14th Amendment's Equal Protection Clause isn't the same as what I think it should be. I think the current interpretation is the Equal Protection Clause is protection from the state from imposing any laws depriving you of liberty, justice, and property. And the reason I think this is that in many court cases, this reason is cited. The state is referred to, so when cases in question with the Equal Protection Clause are brought up, they usually talk about they usually look at how the state is, what is the state's role and how is it affecting, like how would the state affect these cases, and if the state had affected these cases at all. Then we'll go into my first point. So yeah, so the first court case, the one that's mentioned in the book by the author, and one talked about in the lecture is Cruikshank, U.S. v. Cruikshank, and I want to also talk about U.S. v. Reese. I think both of these cases, they used the U.S. Equal Protection Clause, looking at how the state had affected it. Although I do believe more strongly that in the U.S. versus Reese case, they had misinterpreted it. But I think it draws similarities. So U.S. v. Cruikshank brought up in the Colfax massacre, and the ruling was that since this was private violence against government officials, there was no violation of the 14th Amendment. But in the book, and let me see for reference, in the book they had mentioned that it was the state's duties to really enforce this part of the 14th Amendment, and I think that's where they got wrong, and I think it's a little inconsistent with with the interpretation I had given out. And I think the same thing goes for the Reese U.S. v. Reese case, even though, and I think that's much more obvious, where government officials had refused to register African American voters, and the case cited lack of the Enforcement Act did not require to prove a racial discriminatory motive. I think this is that interpret these incorrectly, but I think the U.S. v. Reese case draws similarities to the Castle Rock v. Gonzalez case, where it was more of a question of the lack of the inaction. So the cops had refused to go out looking for the man, so Gonzalez's husband, who had and the U.S. versus Reese case had the voter registrators had refused to register the African American individuals from voting. I think these are very similar, but that they they were both obligated to carry out these duties as so U.S. v. Reese. They should have registered the voters. There was no reason they shouldn't have. And the U.S. in Castle Rock versus Gonzalez, according to the Colorado law cited, they had an obligation to arrest individuals who had violated their restraining order, and for some reason other than that, they refused to do so. I think the Portland case that was mentioned in the second part, in the Part 2 lecture, isn't similar very much at all to Castle Rock v. Gonzalez, because there wasn't any obvious laws being broken. There weren't any obvious laws being broken, and so there was no reason to arrest. In fact, I think everyone would agree that would have been a violation of the man in question's rights, and I think it was a mistake for the insurance companies to settle. But I think they are also, like some of these cases where that were mentioned, they're affected by politics. So I think maybe there might have been an outside factor. Tennessee, and this brings up how an article had mentioned here. Where is it? So the article, I think the article from The Nation, why it's impossible to indict a cop, talks about how the U.S., how the court systems will usually favor the cop's assessment of the situation, and so I think that could have come into play, and favoring their assessment, giving any sort of favorability in court might be getting in the way of this sort of adjustment and holding police accountable. And I do think in obvious cases where the U.S. court had executed Equal Protection Clause correctly, obviously Brown v. Board, where states were enforcing it, it was a separate but equal doctrine that was installed by Plessy v. Ferguson, and I think they had perfectly done it. I think it was obvious. I think the state infringement of liberty and justice was obvious there. But I think another case that is good is Shelley v. Kramer. I think Shelley v. Kramer is a interesting case in where the homeowners in the neighborhood area, most of them agreed to not sell any properties to black families. And when a black family had moved in and the case went to court, the Supreme Court ruled while this is a private actor and not a state actor, so the Equal Protection Clause doesn't have a say in this case particularly. The courts cannot enforce the homeowner's decision to prevent black people or a black family from buying into the property on this neighborhood, so they ruled against the Kramers and the neighborhood. And I think finally, because this video has gotten too long, my interpretation, I think what the Equal Protection Clause should be, I think it should also cover private violence, just like the author had mentioned before. But I do recognize that it's hard to prove motives like this, but I do think not including private violence and private discrimination is getting in the way of letting too many cases slip by where discrimination is being allowed. And we have anti-discrimination and anti-hate laws anyways in the U.S., so I don't think it would be too big of a push to incorporate this for equal protection.